San Antonio, Texas workers' compensation attorney Alan Tysinger talking to you today about the workers' comp contested case hearing. What happens if you disagree with the insurance company about a denial or underpayment of benefits in the case or a dispute over coverage? The Texas workers' compensation system allows you the right to go in front of a workers' compensation administrative law judge to get a final ruling on the disputed issues in your case. The insurance adjuster, just by denying what you're asking for, doesn't get the last word. After the parties have proceeded through an informal mediation called a benefit review conference and prepared the evidence and the documents in the case, the matter goes before a workers' compensation administrative law judge for a contested case hearing. Well, what is a contested case hearing? How do you get there, and what happens? Well, the parties only go that far if they still haven't resolved their disputes after an informal discussion at a benefit review conference. If the parties aren't able to resolve the disputes, the case gets set for a final hearing on a specific date and time in front of an administrative law judge. After that, the parties normally have 15 days to send to each other any additional evidence, exhibits, witness statements, or the identity of any witnesses they would like to use at the final hearing. Other evidence and exhibits can be exchanged as they become available to the parties, but if you have something, it's important to send it within the 15-day time period. The parties can request other documents by subpoena. They can request questionnaires be completed by doctors. They can subpoena documents. They can subpoena persons to testify at the hearing. And at the final contested case hearing, it's like a trial. Each party has the chance to make an opening statement. All exhibits are offered and either admitted or excluded. That would include medical records, medical narratives, witness statements, any claim filings or documents that are relevant to the disputed issues. After the parties have admitted all their evidence and made their statements, each party has the right to call witnesses. That may include the claimant, it may include co-employees, supervisors, anyone with knowledge of the disputed issues in the case. Each party has the right also to call doctors to testify. Doctors may be called to testify regarding the diagnosis, causation, treatment, disability, or even the permanent damage caused by an injury on the job. Then the parties have the right to close the case and make their final arguments. During the process, each party has the right to answer questions under oath and the ability to ask questions of the other side's witnesses in the case. The judge, unlike what you see in typical civil cases, also has the right to ask questions of all witnesses. When the parties have finished their closing arguments, then the matter goes into the hands of the judge. The judge will review all of the records in the case and write a final decision that either awards benefits on each disputed issue or denies benefits. And the parties will be mailed a copy of that decision within about 2 weeks of the final hearing.